May I have your kind attention, please? We'll begin the inaugural session in a short while. May I request all of you to kindly be seated and switch off your mobile phones or put them on silent mode. Ladies and gentlemen, our honorable chief guest is with us. Please join us in welcoming him. A very good afternoon and a warm welcome to our distinguished chief guest and other dignitaries. On behalf of the Competition Commission of India, it is my pleasure to welcome you all for the celebration of the 15th Annual Day. We are delighted to celebrate this year's Annual Day, and on this very special occasion, it is our pleasure and privilege to have amongst us Attorney General Shri R. Venkataramani, who has kindly consented to be our chief guest today, and for having spared his valuable time to be with us. It is also our honor to welcome Srimati Vijayalakshmi Venkataramani, who is here with us today. May I request Srimati Ravneet Kaur, Chairperson, Competition Commission of India, to welcome the chief guest with a bouquet of flowers. May I now request Shri R. Venkataramani, Attorney General, to kindly light the ceremonial lamp and inaugurate the annual day. I also request the other dignitaries on the dais to kindly join. May I now request Srimati Ravneet Kaur, Chairperson, Competition Commission of India, to kindly deliver the welcome address.
Respected Shri R. Venkataramani, Attorney General for India, distinguished guests, ex-chairman and members of CCI, esteemed colleagues, officers, members of the media. It is with immense pride that we gather here today to commemorate the 15th Annual Day of the Competition Commission of India. On this occasion, let us reflect on our journey, celebrate our accomplishments, and prepare for the challenges that lie ahead in fostering an effective, competitive environment in our vibrant economy. Reflecting on our journey, 15 years ago, the Competition Commission of India started enforcing the substantive provisions of the Competition Act with a vision to promote and sustain an atmosphere of healthy competition that is conducive to the interest of consumers and ensures freedom of trade. As we look back, we have traversed a path filled with significant milestones and challenges. From taking action against anti-competitive practices to promoting fair competition, the journey has been both rewarding and enlightening. CCI has been instrumental in curbing anti-competitive practices, dismantling barriers to entry, and ensuring that businesses operate on a level playing field. Our efforts have not only provided innovation and efficiency among businesses, contributed to the overall economic welfare of our nation, and have also protected the interests of consumers. Around the world, we are witnessing a significant shift as countries revamp their competition laws to address the complexities introduced by new age markets. In fact, the digital economy has challenged traditional competition law frameworks worldwide. Countries and economic blocs have responded by either adapting existing laws or introducing new regulations specifically targeting digital markets. There has been a marked increase in scrutiny of major technology companies by competition authorities around the globe. Investigations have focused on practices related to market dominance, anti-competitive agreements, and mergers that potentially stifle competition. The various competition authorities are adopting sophisticated tools and methodologies to analyze markets in the digital era to understand market dynamics, consumer behavior, and competitive effects of digital platforms. CCI is also in the process of launching a market study on artificial intelligence. The transformative capabilities of AI have significant pro-competitive potential, but at the same time, there may be competition concerns emanating from the use of AI. The study will be a knowledge-building exercise to develop an in-depth understanding of the emerging competitive landscape, the development of ecosystems, and implications of AI applications for competition, efficiency, and innovation in key user industries. There is a growing emphasis on consumer welfare in the formulation and enforcement of competition law. Authorities are increasingly considering broader impact of new age business practices on consumer choice, innovation, and overall market health beyond just price effects. This consumer-centric approach ensures that the benefits of competition extend directly to the public. I would now like to mention about some of the current initiatives and achievements of the Competition Commission. In the last over 1 year, the Commission has taken several initiatives to enhance transparency, improve regulatory processes, and make our operations more accessible to the stakeholders. Our enforcement actions have been more robust than ever, with significant penalties imposed on those undermining the competitive spirit of the markets. We have also been a part of several key policy-making discussions to ensure that competition law continuously adapts to the rapidly changing business environment. We have been actively conducting workshops and seminars to educate and engage with the business community on the importance of competition law. In the year gone by, we were engaged in preparing a regulatory framework under the new Competition Amendment Act of 2023, which has been conceived with the need to address emerging challenges and align our framework with international best practices. The introduction of settlement and commitments, deal value threshold for notifying mergers and acquisitions, explicit introduction of hub and spoke models in the statute book, and the innovative concept of leniency plus are all designed to address the complexities of modern markets and business practices. The competition law envisages changes that validate our dedication to ensuring that the law remains robust, responsive, and relevant to the needs of the economy. After extensive public consultation, CCI has introduced new regulations on settlement and commitments, turnover and income, and leniency plus. We are now in the process of notifying the new merger control regulations, and the Commission has also issued penalty guidelines. One of the most important features of digital markets is the tendency towards market concentration, and many digital platforms benefit from network effects, where the value of the service increases as more users join. This can quickly lead to winner-takes-all scenario, where one or few companies may dominate the market. In the digital economy, data is a very important resource. Companies that can collect, analyze, and leverage vast amounts of data can gain significant competitive advantages. This raises concern about data dominance, where control over large data sets can create insurmountable barriers to entry. Many digital markets are characterized by platform business models where a single entity controls access to a wide range of services. This raises issues of platform neutrality, especially when the platforms also compete with the businesses that rely on their infrastructure. There's a growing concern that platforms potentially favor their own services or products. Algorithms play an important role in digital markets, from shaping user experiences to making pricing and product placement decisions. However, the opacity of algorithms can make it challenging to assess their impact on competition. Issues like algorithmic collusion, where algorithms might implicitly coordinate prices or market strategies without explicit human direction, pose novel challenges for us. Addressing these challenges requires a nuanced approach, blending traditional competition analysis with a deep understanding of digital market dynamics. It necessitates regulatory agility, the development of new analytical tools, and novel regulatory frameworks specially tailored for such scenarios. Ensuring that digital markets remain competitive and fair demands that we confront these challenges head-on, with a commitment to adapt our policies, enforcement strategies, and legal frameworks to the realities of the digital age. I would now like to briefly touch upon the vision for the future. Looking ahead, the Commission is committed to being at the forefront of nurturing a competitive culture across all sectors. We are focusing on emerging areas in digital economy which are redefining the marketplace dynamics. Our goal is to ensure that competition law enforcement evolves in tandem with these innovations, safeguarding the interest of consumers and ensuring fair play. One of the initiatives being taken in this direction is the draft Digital Competition Bill, which was circulated for public consultation, and I hope that all of you have actively participated in providing your comments on that piece of legislation. We are also strengthening our international outreach to exchange best practices, enhance our capabilities, and recognize that in a globalized economy, cooperation is key to effective enforcement. As we celebrate the 15th annual day, I call upon you to join us in this endeavor to foster a healthier, competitive environment. Let us collaborate, innovate, and advocate policies and practices that benefit consumers and promote economic growth. I extend my heartfelt gratitude to respected Attorney General for India, Shri R. Venkatramani, for taking out time to guide us and to share his perspective in his address. We are looking forward to his inputs and would greatly benefit from them. I also thank all the stakeholders for their continuous support and cooperation. Together, we can achieve more and ensure that the benefits of the competitive market reach every corner of our country. Thank you for being a part of this journey. Let's work together towards a thriving market economy characterized by fairness and growth. Thank you. Jai Hind.
Thank you, ma'am. Ladies and gentlemen, it's my pleasure to now introduce our chief guest today. Shri R. Venkataramani is a senior advocate and attorney general having over 44 years of practice before Supreme Court of India and before several high courts of the country. He has practiced in various branches of law, including constitutional law, arbitration law, law of indirect taxes, corporate and securities law, criminal law, etc. He has held various important positions, including member of the Law Commission in India in 2010 and again for a further term in the year 2013. Member of Subcommittee on Directive Principles of State Policy constituted by the Commission reviewing the working of the Constitution under the chairmanship of Justice M.N. Venkatachalaya. Co-opted member of the expert group constituted by the Ministry of Minority Affairs under the chairmanship of late Professor Madhava Menon. He was appointed as an amicus curiae in matters of public importance before the Honorable Supreme Court of India. He was conferred with Lifetime Achievement Award in recognition of his acumen as constitutional lawyer by the 9th edition of India Legal Awards 2023. He has been conferred with honorary doctorate by the Chancellor of Maharaja Surajmal Bridge University, Bharatpur, Rajasthan. He has been actively involved in academic activities with publication of several books and articles and has been an adjunct faculty in several law schools. He also has many international engagements. May I now request Shri R. Venkataramani, Attorney General, to deliver the special address.
It's a beautiful place to talk about competition policy. We have on both sides horses running around, which captures your images of what happened when India had to run for its freedom. When you talk about competition, particularly in contemporary India, one's mind goes back to the New Deal and the Great Recession in USA and the history of how the US Securities and Exchanges Commission came into being. And interestingly, Justice Douglas, who became later judge of the US Supreme Court, came to the Supreme Court through the route of competition, this Exchange Commission. And while he was teaching in Yale, he was critical of the current executive understanding of the uncontrolled, unregulated market capitalism of those days. And why do we need to look at all that? It's important for us to look back at history. I don't propose to take you into that very large chronicle history of competition commissions or trade commissions across the globe, but try to capture a few imaginations and ideas which have led us to what we are today, talking about competition. And of course, being the Attorney General by definition, I suppose I am expected to be a scholar and a master of jurisprudence. But while I humbly say I may not be so, and I hope the lecture today will be able to engage myself at a level of many of those who are very accomplished people in the field, including members of the Commission and the chairperson of the Commission. I am not an economist by studies. I am a student of physics. But I suppose physics and economics have some common understanding and basis. So from being a student of physics to be a lawyer in Supreme Court and to understand what law is meant to do in various walks of life has been a fascinating journey for me. And in that context, I try to understand what exactly one can do about, think about, talk about, and debate about what competition law can do for India. Having said that, it's my privilege to be here, honor to be here, to be invited by the Competition Commission, what I call a statutory think tank of India. It is a statutory think tank. We are private think tanks. But when statute confers powers on a think tank like this, well, the mandate, I think, is very, very, very large and huge and demanding. Now, what is economic methodology? Economists do it with models because there is no shortage of demand for the curves they supply. I quote, "This quote is no comment on the discipline of economics, but about the wealth of economic arguments that critique or support competition laws." Why do we need a regulation of all human activity is an ancient but perennial question. This question runs through all domains of law. Indeed, law itself is an idea of regulation. In different regulatory domains, the question is answered differently. In the field of competition law, this question has now traveled seemingly unconnected domains, beginning from prevention of unfairness in competition to price determinations and consumer welfare, and entering the age of common good as the determining factor. Are we transforming what was conceived as a little tool in the field of competition in the ages of antitrust law to a tool of fairness distribution and thus of economic control? Or whether this movement is necessary to balance innovation and creativity and the distribution of the fruits of innovation as we are entering a new age of social, economic, technology and global relationships, in order that freedom of innovation is not substituted by complete state or other coercive controls. Remember, the economist Paul Samuelson thought that he said, markets can work but only with governmental created guardrails. The guardrails include competition regulations, except that the competition law framework may not be equivalent to the sovereign power of the state to occupy basic policy making. I am looking at how the invisible hand made famous by Adam Smith, the engine of free market, and the umbrella of social benefit can coin new ideas of coexistence. In the context of innovation, it is argued that restraints on innovation can impose a far greater cost on society than simple restraints on competition. Second, because innovation is behaviorally much less predictable than price competition. Is causation and harm are particularly difficult to prove. This gives insights on procedural tools of effectiveness and enforcement ease. After all, an enforcement that is cumbersome or of evidentiary errors is antithetical to justice fairness. As we are debating the effectiveness of regulating competition, which means taming the shrew, we have in our handbag the advantages of the US antitrust law with all its wrinkles, the European law on competition with all its early exclusive focus on European market integration, and about more than 140 countries experience now on competition stories. We are all called upon to look at organized distribution networks that dominate the economic landscape today. They cover everything from the sale and maintenance of automobiles, including tractors in the agriculture sector, and computers to food franchising, drugs and hospital services, education services, and entertainment sector, in all of which rules of innovation and establishment, sustenance, clamor for freedoms. These freedoms seem to be in unease with regulation, sometimes for wrong reasons. The task of navigation between incentives and the free riding of market ideas will be a distinct legal innovation, distinct from other regulatory thoughts like SEBI, etc. Indeed, the 2023 amendments to competition law are going to be experiments of a different kind. They cannot be assessed without a structured social and legal impact studies, which will include changes in behavioral components of all actors in the arena. Common examples of human behavior are how we stuff our baggage in aircrafts without common concerns and the intervening hands of the air hostess in baggage setting. Of course, competition law is more than the smiling air hostesses. I wish to quote Adam Smith here. He said, in general, if any branch of trade or any division of labor be advantageous to the public, the freer and more general the competition, it will always be more the so. And people, he said, people of the same trade seldom meet together, even for merriment and diversion. But the conversation ends in a conspiracy against the public, or in some contrivance to raise prices. Say, though the law cannot hinder people of the same trade from sometimes assembling togetherness, for instance, the cartels of today, it ought to do nothing to facilitate such assemblies. Unquote. Let me look at few broad aspects. They are the international convergence of competition laws and the takeoffs therefrom, the challenges to regulatory laws in general, the task of redistribution of economic power between consumers and suppliers inter se, the newly emerging sustainability consideration and competition policy, as the business of sustainability will govern the sustainability of business, and the new challenges in the light of digitalization. We also have questions such as what are the effects of competition laws on wealth distribution, and whether competition law could provide a viable and effective instrument to address economic and other connected market inequalities, which are natural consequences of market growth. Let me first have a brief mention about digitalization. All competition regulators across the world are grappling with emerging trends in digital markets. It's old news that data is the main currency of the internet, and access to vast quantities of user data is thus coveted. By now, you have seen the action taken by a number of competition regulators worldwide against the gatekeepers of data, as it is called, especially in circumstances where this access point is used to their own benefit and to the detriment of consumers by stifling competition. The current debate on this is around the Digital Competition Bill, as was mentioned by the Honorable Chairperson, which is a proposed legislation that seeks to act on the learnings of competitive competition dynamics in the internet and the digital world over the last decade. The debate is essentially one of ex post action, that is investigation and sanctions, and the possibility of false negatives on the one hand versus an ex ante action, that is bans and prohibitive rules, and the possibility of false positives on the other. The debate is also of casting a wide regulatory net, agnostic of the activity involved versus having more market-specific regulations. To aid this, Tools such as behavioral economics are useful. Behavioral economics provides insight into human preferences, which the assumptions made in traditional economic models sometimes completely ignore. Such exercises become all the more important when considering the uniqueness of the Indian market, Indian people, and the non-uniformity of consumer preferences across regions as well as across different types of population centers. Ever since the intrinsic limits of competition law were highlighted by Judge Frank Easterbrook in his seminal article, The Limits of Antitrust, there is a burgeoning literature on the subject of under-enforcement or over-enforcement. The combinations of relatively centralized enforcement of competition law and decentralized private enforcement and the variations of the enforcement mechanisms. Given the existing framework of a competition law and the lessons learned and to be learned, will need placing our debates a little beyond our domestic frontiers, at the same time to pursue our specific national matrices. The 5 forces that shape industry competition, namely, all of us are familiar with that. 1, rivalry among existing competitors, threat of new entrants, bargaining power of suppliers, bargaining power of buyers, and also the perpetual threat of substitute products, that is, new products or services. For example, we can see the market of commercial aircraft with Airbus and Boeing. The rivalry between these dominant producers are very strong. The threat of entry substitutes and the power of suppliers are benign, as it is called in this field. While in the passenger carrier service, an Indian scene has shown many stories of the rise and fall. Again, in the movie space, with the proliferation of actor and players in substitute forms of entertainment, the power of producers and suppliers of service, suppliers of movies, which is critical, assumes importance. The photographic film industry is another example, with Kodak and Fuji were to cope with the advent of digital photography. In many of these instances, intermediates, customers gain significant bargaining power when they can influence the purchasing decisions of customers downstream. Consumer electronic retailers, jewelry retailers, and agriculture equipment distributors, and even packaging industry are examples of distribution channels that exert a strong influence on end customers. The e-commerce platform and its monopoly by few international giants is another example. The very width of their control and user inclinations generated by them, zealously created by these giants, can be an area for scrutiny, and fittingly, e-commerce policy as one among the 100-day agenda of the government to come in. CCI has many such fishes to catch. How do we articulate fairness and equal or level playing field in all these areas? How do we look at the startups and the excuses, if any, we may have to provide for their economic deviancy, if one may call it, only to enable over a period of time their sustainability itself as in promotion of fair competition. In all this is the role of law an intruder or a necessary intervener. In all these, the consensus of the international community about the role of competition law is not very evident. The year 1984 saw the Havana Charter, which included a chapter on restrictive business practices. All regulatory ideas are either simple, namely prohibition, or multi-aspected, like restrictions coupled with permissions. In both cases, we use sanctions and penalties as instrumental tools. Almost all laws use combinations of these. But what combinations are relevant and ideal for a particular area, a human activity, will depend upon the desirability and manageability of procedures and outcomes, as also the wise scope for freedoms, all of which will serve common welfare. In the context of every class of service or goods, common welfare will mean sections of the community or the whole of the community, as the case may be. Where pharmaceutical and health services are concerned, it will mean community as a whole. In other contexts, it can, like education sector, real estate sector, hospital, or communication or transport sector, and all their subdivisions, it can be a subsection of the community. But in every sector, many products and services are interconnected or some stand alone. I will deal with this interconnectedness aspect a little later. A common feature one can notice as technology develops is the push or drive to connect two or more markets together. It has been noticed that in technology-rich markets, competition policy disputes involve claims about interconnection, compatibility, or interoperability. The good old motion picture patent case of 1917 involved tying arrangements. The Micromax case dealt by CCI on a complaint from Micromax that Ericsson was indulging in unfair trade practices by demanding unfair, discriminatory, and exorbitant royalty for its GSM technology-related patents is a contemporary example of which the US Supreme Court would have nodded in a big way. We have a large volume of studies and reports and judgments that take us into witnessing the patterns and history of all market arrangements to generate, capture, retain, and control the demand and supply element of free markets. I repeat, the patterns and history of all market arrangements to generate, capture, retain, and control the demand and supply element of free markets. The field of law and economics, which has studied all this, as Professor Sunstein noticed the year 2016, has virtually altered and challenged our legal thinking in relation to all regulatory domains. John Kenneth Galbraith, writing in 1950 and talking about how powerful buyers might offset powerful sellers charging monopoly prices, used the term countervailing factor, countervailing power, to describe the power equations in markets. Writing a little later on the economic and legal analysis of antitrust law in the US, Carl Kaizen and Donald Turner, while acknowledging the existence of powerful buyers in some situations, had almost discounted their significance for antitrust. What is this matching of powerful buyers with powerful sellers? The presence or absence of powerful buyers, all of us know, is a factor that goes into merger analysis. Probably we are talking about bilateral monopoly of buyers and sellers and all its spectrum and the relevance of strengthening this in the entire debate on competition law, the bilateral monopoly. How do we design and promote this distribution of powers and bring in the public interest power as the moving hand of demand and the market duty to supply? And how do we harmonize the private initiatives to create, innovate, and equitably retrieve the due returns of innovation and creativity? We also need to keep talking about why some laws are so effective being obeyed by citizens and enforced by functionaries of the state, and some are not. Perhaps every law goes into a disputant state, but the nature of dispute marks the distinction. Many litigations are in the realm of procedures or misapplication or even discriminatory application. Kaushik Basu asks a simple but important and puzzling question: why merely putting some ink on the papers should change human behavior? A very important question. Changing human behavior in the world of markets, where freedom is a driving force, is no easy task. At a practical level, we are called upon to ask the question: is the competition law adequate to this task? For the law is called upon to deal with the emanations of market power in all its manifestations. Just as human innovations are dynamic, so also are market maneuvers. Imagine pillows which are too hard and painful to the neck, and those which are too soft, which sink under the weight of our heads. We want the market to be malleable and non-resistant. The challenge, therefore, is to have a basket of principles that will not treat the market as a sinner, those sinners are the fishes that abound, but to provide very relevant, empowering, and synthesizing principles. The move towards sustainability takes us into a more insightful and engaging areas. The existence of dominance and abuse of dominance without reference to other factors need not be the only major concern as we step into this area. We have the European Union investigation in the Philips Orama case, which found that their agreement in the LED market was a measure of encouraging sustainable innovation without monopolizing or limiting competition. Another instance is the Sidweb-Nesten and Grus case, where the European Court of Justice was invited to address exclusive waste processing contracts, where a municipality excluded a qualified company. This case sets some criteria for addressing dominant abuse for environmental reasons. The European Commission scrutinized the Arabis Metallo case, where their merger showed significant environmental benefits. The CE-CED case is another example of promotion of energy efficiency by European appliance manufacturers. Probably sections 19, 20, and 54 of the Competition Act have some potential in this regard, which needs to be explored. Before concluding, a few words on privacy and competition. Privacy and data have now assumed greater importance in the competition discourse. If I'm not wrong, it began with the German Competition Authority looking at privacy from a competition and constitutional lens. With an increasingly expansive recognition of privacy as a fundamental right, tied with the importance of the data protection laws, its filtering into competition was inevitable. The CCI is already seized of cases in this sphere, while constitutional cases are pending in the Supreme Court. Establishing the contours of privacy from a competition perspective is very important. Therefore, it's imperative that the regulator always be keeping up with the times. In this regard, CCI's 2020 market study on e-commerce in India was a welcome step, since it noted contemporaneous conduct and gave indications as to what kind of market conduct may result in competitive harm. Such studies should be carried out with sufficient frequency for keeping pace with the evolving landscape in the digital and internet markets. In addition to this, having detailed guidelines based on such studies of the Indian market will give the market players useful signposts as to the likely proscribed conduct. This would foster greater certainty, would empower smaller players, and caution larger ones on practices which are harmful to competition. In other words, the CCI has to speak through more than its decisions. One of the famous statements made by John Maynard Keynes, the economist, in the year 1933, and I want to look at how we moved far away from it. This is what he said: the decadent international but individualistic capitalism, in the hands of which we found ourselves after the First World War, is not a success. It is not intelligent. It's not beautiful. It is not just. It is not virtuous. And it doesn't deliver the goods. In short, we dislike it and we are beginning to despise it. But when you wonder what to put in its place, we are extremely perplexed. For we are in a state of perplexion today, looking at the world of free market and the entanglements in severe national, global, economic, social, political entanglements. I think if John Maynard Keynes had been here today, he would have rewritten this and said, I'm not perplexed, but I am bewildered. I wish we are not bewildered at all. What I want to say is that evolution is, in essence, confronting all challenges. Darwin knew it better. Dominance, I think, is intrinsic to economics, just as distribution of the material resources of the community for the common good is a part of the constitutional goal. I consider the market a free market because it has two important elements: innovation, creativity, and the need to push the frontiers of innovation and creativity is also a material resource of the community. The free market is a material resource of the community. And if therefore competition comes in to say, your material resource will be for the common good. And this catches, in a sense, all the attributes of the competition law, if I put it like that. But then ultimately, we have to ask a question. Is there a tension between competition and fairness? So fairness in the context of constitutional law, administrative law, and not necessarily fairness in the context of market intervention by competition law. So we have probably to evolve an index of fairness in the market freedoms, etc. So that calls for a wide engagement of all of us here today. So when the legal community, which is now engaged in a wide range of what called adventurous ideas, put it like that, you have several tribunals operating in very many niche areas. You have several questions which flow across the globe and land on our laps, and we are asking for our own solutions. So the legal fraternity in India is no less than the rest of the world in finding solutions for this. I do not think that we need to go back to Adam Smith and find out solutions for the invisible hand. Probably we need to rewrite the invisible hand by more visible hands, the visible hands of the state not taking over, but looking at. Taking over is different from looking at. So China is taking over, India is looking at. So that's how I think the things will have to be drawn. Therefore, we understand, and if we're able to, plow it more and more, I'm sure all of us, with our very, engaged minds, will be able to produce wonderful answers to the questions which confront India today in marching ahead towards equality and fairness. The constitutional goals all of us would like to talk about. For I am so extremely happy to be here today evening, and I was told that, of course, I could have gone on for another half an hour by testing your patience. But I only wanted to share a few thoughts which came a couple of days ago. When the invitation came about 2 weeks ago, I asked the chairperson, are you really sure that I can come and do justice for the annual lecture? Annual lectures are very important events in the history of an establishment, and they must be of a certain quality and status. So then I had to work on that. And given the engagements over the past couple of weeks, and I had to steal some time in the past 3-4 days, sitting at night, looking at my computer, and looking at what the rest of the world is doing on competition law. It's a great learning experience for me. And I think for having given me this opportunity of learning experience, I thank the CCI for calling me today afternoon. It's a wonderful evening to be with you today. I'm sure we'll be able to travel together many, many miles ahead. Thank you so much.
Thank you, sir, for your inspiring words and kind appreciation. Your vision will guide CCI through its journey to come. May I now request Shri Anil Agarwal, Member, Competition Commission of India, to propose a vote of thanks.
Honorable Chief Guest, Shri R. Venkatramani, Attorney General for India, Chairperson and members of the Commission, distinguished guests, officers and colleagues of CCI, ladies and gentlemen. It is an honor for me to propose a formal vote of thanks on the 15th annual day, a very significant occasion of the Competition Commission of India. Annual Day, though a yearly event, is a good occasion to reflect upon our learnings, our achievements, the challenges faced and the milestones achieved, not just over the last 1 year, but over the lifetime of the organization that have contributed to evolution of this organization. It is also an occasion to look forward to another promising year, full of opportunities to make a difference through effective interventions. 15 years back, on 20th May 2009, the enforcement provisions of the Competition Act were notified. Over these years, the CCI has emerged as a pivotal force in sculpting the contours of our nation's economic framework. From its inception, our journey has been marked by significant regulatory advancements and landmark decisions that have established robust precedents for fair market practices. Through rigorous analysis and judicious enforcement on the antitrust side, as well as in regulating complex merger transactions, we have navigated complex competition challenges, adapting our strategies to meet the ever-evolving economic landscape. Apart from the significant quantitative accomplishments, it is the behavioral changes, sir, as you mentioned, of the market participants that substantiate the effectiveness of our enforcement decisions. It gives us a great sense of satisfaction that players in different sectors have responded to our interventions, modifying some of their long-standing practices to bring them in alignment with principles of fair markets. Sir, I express my sincere gratitude to you for sparing your valuable time and enlightening us today. Whether you are a student of physics or law or economics, we are inspired not just by your scholarly discourse today in this event, but your overall outlook towards life, relationships, and society as a human being. And I am referring here to your book that you've launched recently, Roses Without Thorns. And you've explained yourself, you've explored a world without thorns. Roses convey the idea of compassion. Thorns mean all those negative factors, feelings, emotions, ideas, which divide people, individuals, communities. Thorns have become a part of our lives because of human nature. If life can be roses without thorns, our endeavors, our actions, our relationships can be roses without thorns, there can be a world where we can have roses and without the thorns. This is what you've said in one of your interviews, sir. Now, these are profound and very, very inspiring ideas. Translating into action for regulators like us, this would mean to try to identify and then gradually reduce and remove these thorns that crop up in our functioning at various levels, not just internally, but in all our interactions with the outside world, in all the stakeholders. We look forward to continuing our work with renewed vigor and commitment to reducing these thorns in all our areas of work. Thank you very much, sir. I also extend my heartfelt thanks to all our distinguished guests and stakeholders, government officials, members of the academia, lawyers, economists, and all other delegates. Your presence here today signifies the strength of our collaborative efforts. Your continuous support and active participation in our activities are critical in crafting a competitive marketplace. Your perspectives and expertise are invaluable, enriching our discussions and helping us refine our approaches to enforcement and policy issues. I compliment the team CCI, whose meticulous planning and execution have made today's event seamless and successful. Your attention to detail, coordination, and effort in creating such an engaging program must be appreciated. Thank you very much, everyone, and have a good evening.
Thank you, sir. May I now request Srimati Ravneet Kaur, Chairperson, Competition Commission of India, to present a memento to the Honorable Chief Guest as a token of our gratitude. This brings us to the end of the program. On behalf of CCI, I thank each one of you for being here and making this event a success. I now invite you to high tea. Kindly join us for the high tea.